Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in.
Hello, everybody. Well, we popped on over from Karen Reed. Now we are waiting for Miss Lori Vallow, and she's still waiting for pretrial hearing. It was supposed to have been live already. We also have, in about 45 minutes, Monica Smittilli. That one, I may just look at today until lay down. Welcome so much for coming over here. Siva! I didn't do a teleport. I didn't have time. You're first in chat. You get extra entries, my dear. I wonder if she is pleading guilty. I wonder if she's going to plead guilty. Here. Y'all, exciting. I don't know why I get so excited over the space shuttles or whatever. I just do. Just careful what I want to say. But I know I'm muted. I was talking to my son. Okay, so I got that done. And I'm trying not to cough in your ears. I don't have any cough drops, so let's see if I can use gum. I'm trying so hard not to blow y'all's eardrums. I'm trying. But I don't want to get in trouble for putting up a stream for Monica and then just putting my picture up. Like, let's see if I have it. This. or like that, and go lay down for a while. But I think I'll get in trouble for that. Do we know why? They have their chat turned off, so of course I can't find out why. I can't. I'm trying. I wonder where my honey boo went. For those of you who don't know, I got a boyfriend. I know, right? I don't know what I did. I don't know what I did. Let's see what else is going on. I'm not sure this. Not what I need. There we go. Oh my gosh, yesterday, you might want to see this. The only thing that makes me worry about going on a cruise
on the shore, his captain sends a desperate mayday call, and experts prepare for a disaster on the scale of the Titanic. This is a tale of shocking oversight, the story of how the Viking Sky cruise almost ended in catastrophe. On March 23, 2019, the Viking Sky was sailing through the infamous Hustadvika Bay area when its engines abruptly shut.
That is something. I want to go on a cruise, but that does concern me. I know, right? I'm looking for us to follow something. If I can. Forgive me, I'm trying my best today. And I know it's not that great. Nope. Everybody's waiting for this. Gosh, I didn't know so many people waiting for her. Oh. Gerald, you're too kind. You couldn't carry me, babe. Appreciate the thought. He goes, I'll carry you if our cruise goes down. I'm like, you couldn't, babe. It's okay. I'll be carrying you, boo. I'll be carrying you. Trying to find something for us to watch. The Karen Treat was interesting. For a minute, I was like, EDB. Oh, I was so ready for that. I was so ready for her to sit there and say that she's going to kick out the attorneys. I'm like, oh my God, no. And then she goes, Mr. Giannetti can do the trial all on his own. And for a second there, I thought, oh boy, we're going to have a problem. Yay, now we at least have this. We're getting there, y'all. Ponderosa Ranch in Klein Village, Nevada, the history. I went to the Ponderosa Ranch Bonanza house when I was like 10 years old. I love the Ponderosa Ranch. I wonder how much it's changed in 44 years. Oh, God. I don't either. I think we're going to have an overlap because April 1st is when they're supposed to start with the read. And then you have 4-ish weeks, 3 to 4, maybe a little more weeks for the prosecution, a week and a half for the defense. It's going to go over into hers. Do you know what, Gerald? That is true. You are a stronger swimmer. You're a Green Beret. Should be. Can you believe my man was a Green Beret?
This is State of Arizona versus Lori Daybell.
Okay, I have the sound up.
21-001-704.
Your Honor, for the record, this Trini K on behalf of the state, and for the record, the next of kin and the victim in the 2022 matter are appearing virtually.
All right.
Good morning, Your Honor. Pamela Hicks and Robert Abernathy as advisory counsel for Ms. Daybell.
Go ahead and announce.
Lori Daybell.
All right. Thank you.
Rose?
My courtroom assistant said there's some issue with advisory counsel at the table.
I apologize, Your Honor. I didn't think about the logistics, so I'll just let Ms. Daybell.
Okay.
Yeah, I was going to ask if I could have my investigator up here at the table, because if I needed to ask him something, then I need him available.
Yeah, any side can designate an investigator to sit with them through the trial and through court proceedings. So that you can have, if you can fit 3 chairs there, that's fine. Otherwise, advisory counsel could scoot her chair behind, whatever you think is logistically easier.
Appreciate it. Thank you, Your Honor.
All right. I just received word literally 2 minutes ago that we will be using Judge Kemp's courtroom, and we can use it for the entire first trial.
It's a big,
which is in the South Court Tower, which will give us more space as needed. Have the parties, I had my staff drop off the proposed questionnaire on your table this morning. I know you just got it this morning. You may need some time to read through it. That's my proposed questionnaire. Obviously, there's maybe a lot more questions that either side would like to ask the potential jurors in follow-up. So this is not limiting what would be asked ultimately to the jurors. In addition to this, the questions in this questionnaire, when the potential jurors come in, I always go over the burden of proof. I go over credibility of witnesses in a little more detail, especially as it pertains to how people perceive officer testimony, and some other areas I'll highlight. So I intend on asking more than just what's in this questionnaire, but this questionnaire is intended to get through some of the bigger issues, such as pretrial publicity or opinions people may have had, or exposure to the case people may have had, and then it has the questions where we may lose additional jurors on the trial schedule, and then victims of crime, views about police officer, and then if they've been charged or a close family member has been charged with a criminal offense, and to explain that. Any comments from the state?
Judge, in terms of publicity, I think my concern would be that when the jurors come in here and start hearing about the case or hearing testimony about the case, they'll hear the names Tylee and JJ, which obviously were more, there was more publicity about those than about Charles Vallow. And so I think if we really want to ensure that the jury is unbiased and has had no pretrial publicity with regards to the defendant, we're going to have to question them as to their knowledge of her other convictions out of Idaho. That was something that was just incredibly all over the media.
I agree, but I think that may happen in individual voir dire. This initial questionnaire, if they recognize the name Vallow or Daybell and they've been exposed to something in the media about it, they should tell us about what they know about it and about whether they know about that other case and whether they know about anything that happened to it about it. So I anticipate losing a number of jurors just based on that. But I agree with you. Some may say they've been exposed to it, but it wouldn't affect their ability to be fair. And in individual voir dire, we can explore those options. I don't want to necessarily taint the whole pool by saying, hey, she's got these convictions in this other state.
And Your Honor, I don't propose we talk about the convictions, but we will hear the names JJ and Tylee in this trial. So that's my concern, is if we don't raise those names, whether or not we put them in the list as people that they may hear.
What I could do is on question 15, where it lists out my name, the court staff, I need to include your name, the attorney's names, the advisory council's names in there. I'll add those. But at the bottom where it says other potential witnesses, I could do a third or another category that says other people that may be referenced but are not going to testify and list those names. That's fine. Is there any in addition to those two?
That would be the only for that. I think the other issue is, of course, the defendant's supplemental 15.2 names.
When was that filed? I haven't seen it.
I filed actually 2 motions to preclude them all and emailed them to your court Sunday.
Okay, maybe that's in my folder. That's on my desk. Before we
Defense filed that on the 12th of March.
Okay, before we get to that, let me ask the defendant. Other comments on the proposed questionnaire and the information that we're going to put in there?
I think it's
Don't know.
What's that?
pretty clear.
Okay, do you have any objection to listing Tylee and JJ because they will be mentioned?
No.
Okay. All right. Let's take a look here. Let me ask the state. You have 21 witnesses listed. I need to look at the defense witnesses that were listed. And we're after jury selection. I recognize jury selection could take longer than the initial week that I've set forth, but from April 7th to May 15th, the current screening, that is 20 full days of trial and 2 half days. So essentially 21 days of trial. Do you really think we need to screen that for? I know you're being overly cautious.
I think, especially given that I'm not positive we'll pick a jury in that first week, I think we should, Your Honor.
All right. Defense have any comment on how we're screened through May 15th?
I think it's plenty of time, Your Honor, myself.
Of course you wouldn't.
All right, let's deal with a couple things. First, I've received the notice of compliance. That was when the defendant requested the Gilbert video. Is that apply to the second case or this case?
Your Honor, it's an incident that occurred in January. It's not really, it was disclosed because it is mentioned in the DR. The defense had filed a motion for the state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video, or that they don't have to give it to me because it's not attached to that DR number.
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it,
A mitigator.
a mitigator.
Showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed.
I will tell you why they won't, because that is my former team, and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right. Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you, or did you have to start from scratch?
No, from what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn on any notes, any work product, nothing that they had done to that point. And they continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
All right, I'm gonna make an order, and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council. To makes Hicks look like you want to say something.
I don't know.
What? Where did she go? Yeah, you got that right, Gerald. You're not talking in chat, Gerald. You're talking in text. But you're right. Those who have themselves for client is a fool.
No, I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to advise.
I don't know what she was looking for. But hey, babe. She's saying her previous team didn't turn over information they should have. And she's whining like a baby.
Advisory council when they withdrew.
But they still don't have to turn over work product. Sorry, guys. I am still struggling. I don't know what she's doing. I don't know yet, love. No. Thank you, Haley. This has been bad. I haven't had, he's reading something. I haven't been sick like this in a long time. My temperature was at about 4 this morning. I don't know, 101.4, and it went to 102.7, I believe. I'll have to look at my text. I ended up sleeping in the bathtub in cool water, what you call sleeping, to get my temperature down.
All right, so I've read the
Thank
defendant's
you, man.
disclosures that were filed March 6th and March 12th, as well as the state's motion to preclude. And well, let me start. Have you received any response from the defense, anyone from the defense team since you filed this on March 16th?
Your Honor, last night at 10:30 or so, defendant's investigator sent over a list of the addresses of the witnesses. I did speak with him this morning. I still am unclear if defense will be setting up those interviews or if they will be providing phone numbers to the state to set them up ourselves. As for the expert, again, last night at like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own subright or extractions. So obviously the expert hasn't even begun work, let alone.
Thanks, babe.
They've also requested all impounded items from law enforcement. I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
All right, let's set aside Dworkin for the time being. So well, let me ask the investigator. What's your name, sir?
Jeff
Jeff what?
White.
Okay, Mr. White, are you going to be setting up interviews for the state to interview whatever potential witnesses the defendants noticed?
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that these are the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one.
Which is who?
Which is Nate Eaton.
Okay.
Whoa, ma'am, you don't interrupt. You interrupted your own investigator. Girl, you better back off.
When you say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
Prosecution.
So I know that they had their address.
Honey boo, honey boo, honey boo. Listen. The police are not the same as the prosecution. The prosecution has a right to interview before trial and hold a deposition of every witness. Just saying. So what you just said doesn't work.
Addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these people?
Your Honor, the
They may be
first
referenced.
listed person is a reporter. So I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So that's what I stated.
So, Your Honor, the point is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
All right, so it's premature to address these today. The state's going to have to interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute out there as to whether or not they'd be called, I'll have to deal with that as it comes up. But if they're unable to be located or interviewed, obviously they won't be called at trial. Mr. Dworkin, if you want him to do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th
Well,
from OPDS.
you're the one pressing for your speedy trial, so you kind of have to make a decision on we're set for trial. You want to go to trial or you want to have him do that work that you want? Because I don't think both are going to happen. Even if you got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that. And I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
Well, the report's already late technically, but if it were allowed, first of all, it's going to take time to coordinate him getting let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone, Charles Vallow's phone. And I would like a copy of the extraction that they took from it. The digital forensic extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
Yes, Your Honor.
Was that part of the initial terabyte?
Yes.
Excuse me.
Yeah.
Everything that I have is on a 22 terabyte. So if hard drive. So if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I
Terabyte.
understand that.
Okay.
So what's your proposal?
I'll take it up.
I mean,
That's a lot.
If you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the Cellbrite extraction already for that requested item that's been in defense possession for however long now. I'll take it up to Lori. So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
Your Honor, I would ask leave that depending on what Mr. Dorkin says, that
Well,
would
it
put
could
this,
still be precluded because depending on what his opinion is, first of all, it's late under the rules of evidence and rules of disclosure. And secondly, depending on what he says, the state would have to have an opportunity to consult with an expert as well.
Yep.
So even if he got something
Exactly.
done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
more than a year, Your Honor.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January and last Friday, he got approved.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that,
I would like to do that, but my situation in my housing department precludes me from doing that.
from asking for a continuance,
No, from getting things done in an effective and quick manner.
all right, well, so you're
Spoiled
telling me you don't want a
brat.
continuance because any information he has
Well, Brat,
at this
not
point is
much.
could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
Okay. So I guess I'm gonna have to cross the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Your Honor, we have a little over a week to try to interview these people, so I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
I also obviously ask to preclude them regardless,
Right.
based upon what they may say.
All right. That may be beneficial to Lori Vallow Daybell. There we go. Lori Vallow Daybell, because she just said, I got a week or so. I'll get to who I can get to, and who I can't, we'll just exclude. Regardless, we'll preclude them. So that's going to hurt the defense. I don't think the defense is that worried about this case, in all honesty. I wouldn't be.
All right. What else do we need to address today then?
Your Honor,
this-
the only other motion that we did not address last week was the state 609 motion. I presume the defendant will likely testify, so I don't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions. But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions, as opposed to what the nature of the conviction are. But that would be up to you, whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility. So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write out all your questions that you want to be asked and have one of your advisory councils ask those questions to you when you're on the witness stand.
Right.
Okay, so you can't take the witness stand and just
No
give a
narrative.
narrative. It'll be question and answer.
So am I supposed to reply to the 609? Is that what you're saying? And ask for it to be sanitized if I want that?
We can talk about that when we actually have a 609 hearing, but yeah, you can make that request orally. You don't have to do a written response. I indicated last time for your opening statement and closing argument and questioning witnesses that you'll pretty much be limited to the podium. We'll be in a different courtroom apparently for trial, but it'll be set up very similarly. Either your investigator or one of your advisory councils will approach witnesses with exhibits if you have to show a witness an exhibit. So I'll have to do the same limitations on the state. The state would be confined pretty much to the area of the podium, and the state would have someone assist in approaching witnesses with exhibits and that sort of thing. All right.
I have some motions that I'd like to file. I've had a really hard time getting, my paralegal
copies
is
for the
very
state?
busy. I don't have copies.
All right, we'll make copies and give them to the state, and then we'll file them, and depending on what they are, I'll rule on them as the response and replies come in, or we may have to address them.
Is that a homemade wedding ring on her finger or left hand?
Depending on what they are.
Look,
The state would be
That I'd like to file.
copies and give them to the state, and then we'll file them, and depending on what they are, I'll rule on them as the response and replies come in, or we may have to address them
interesting.
depending on what they are. So plan on that questionnaire going out. I think we said next Thursday, the 20th, will be sent out to potential jurors.
Yep.
For the first batch of jurors, and then the responses would be cut off on the 26th.
Judge is going to be sent out Monday the 24th and will end on Monday the 27th.
All right. And then I'll meet with the parties on the 31st to go over those remote responses. So that'll be the 31st at 10:30 a.m. Then again, I'll just reiterate on April 1. Are we having we're not having walk-ins, Izzy, until the 1st?
Correct.
Okay, and then on the 1st, we will meet again, and for the rest of that week, we'll likely be meeting at 10:30 and continuing with jury selection every day until we get enough jurors. Hopefully we get enough the first week. If we have to, we'll go into the second week.
So she's going to be starting jury selection April 1st. Oh, gee, gad. We got both going at the same time. I may be doing Karen Reed in the morning
Judge?
and Lori Daybell.
I know that
Right.
I'd given you a date that I was going to need to be dark on. I'm going to put out there, since I obviously don't know when we will get the jury picked. I do have some witnesses that are flying in, so I may have some days where I may need to end a little early or whatnot to try to accommodate some witness schedules. But I'll keep the court updated once we get a jury picked.
I think we'll have a good idea by about day 2 of jury selection, whether we're going to need to go into the next week or not. That reminds me, though, is I would like the parties to plan on, we're going to have a much better idea after about the second week of trial and the first trial, how the second trial will unfold as far as how many jurors we might need. But I would like the parties to plan on doing another remote questionnaire with a much larger pool for the second trial and meeting on Friday, May 30th. I'm just giving you a heads up as far as this is concerned. And then for scheduling purposes, so everyone knows, I'm planning on probably going Monday through Friday of the week of June 2nd, as well as Monday through Friday, the week of June 9th, to try to get as much done as we can. And then there's going to be some dark days there toward the end of June, but we need to get it done by July 4th.
Your Honor, when are you planning on starting that trial?
So jury selection would be the starting May 30th. All right, anything else from the state for today? If you want to stick around, we'll get you copies of those motions.
I do. Your Honor, I guess the only other thing is for the questionnaire, are we going to put in the defendant's 15.2 witness list?
I'll put in those names preliminarily. It doesn't hurt, just in case anyone is called from that list. And if anyone knows any of those people, I will put that in actually. Anything else from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. They've disclosed everything they have. So I'm going to make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them, or on the other hand, since it was told you secondhand or showed you secondhand, whether it's something different than what you thought it was. I don't know. So I'll make an order that they hand over all those things to you so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
And in that order, they'll give it to my advisory council, or
Who do you want me to, I was going to say give it to your advisory council. Do you want a more narrowed order? Maybe any mitigation work that was collected, or do you want a broad order that's basically everything in their possession?
Well, it would be nice if they could turn over everything in their possession that we worked on.
I was just thinking
together.
it would be easier for you maybe to find that needle in a haystack if it was a more narrow order.
Well, she knows what the link is and she could just give it to us, and we asked for her to do that, and
What's that?
the attorney said, no, she can't do that. She can't give you any.
What's that mitigator's name?
My mitigator's name, Pamela.
On your prior.
Pamela Kearney.
Do you know how do you spell Kearney?
Cerny.
All right, I'll make a specific reference to that.
And do we need an order, Your Honor, to pick up my husband's phone at Chandler Police so that Lonnie can do the extraction?
Well, you already have that extraction in your discovery. What's the state's position on Lonnie Dworkin meeting someone at, you said Chandler, right? Chandler
Yes, at
Police
Chandler
Department
Police
to do another extraction.
Your Honor, obviously the state and defense have always had stipulations so that should something happen to the device while it's in the possession of Mr. Dworkin, that there are now no issues with chain of custody or anything else. So the state would have to draw up a release, have that scheduled on who it's going to be picking it up, have the defendant sign that release indicating that she understands that should anything happen to that she waives those rights to claim those things. So
I think what I was asking was, does Mr. Dworkin have the ability to just do the extraction on site?
on site where? At Chandler?
At Chandler.
I don't think the police departments allow anyone to go in there and conduct their work in the police department.
Okay. All right, so to maintain the chain of custody,
Yep.
the state can draw up an agreement, and if the defendant signs that agreement, then Mr. Dworkin could pick up that phone.
That's perfect. Logistically, how's that going to happen?
She's gonna forward that to your,
That's your problem, Boo. You're your own attorney. I shouldn't have to tell you how to do your attorney's job. That'd be you.
investigator, and I guess he'll have to come down and have you sign it.
Okay.
All right. Be at recess.
Coming.
Okay. Let's do the giveaway for this one. How about that? Here we go. Good luck. Congratulations, Dave. You got an entry to the fabulous giveaway at the end of the month. I'm trying, y'all. You're welcome, Dave. Congratulations. We also have, are you ready for this? Let me get this up here. I didn't know that this was happening. Aiden Carney, arraignment at the Sutton District Court today. Yep. So that's fun. I don't want that. Give me a second, y'all. Oh. Save. I'm adding the redirect. Okay, guys, let me get that up and running. And that can go bye-bye. That's 0. And love affair, Monica. Ooh, excuse me. I really want to say thank you for everybody who's sticking with me. It's been a very difficult day. And it's hard when you're not feeling well to do this. And I know I'm a hot mess, but I'm here. Y'all are here. We're all here. So thank you so much. I appreciate you. We're going to get the Monica Simatilli trial up and going. StreamYard giveaway, StreamYard. Going live here. Give me a second. Okay, guys. Thank you so much for joining. See you on the other side.
Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.